second quarter about to commence with first down 9. This is 38. Period check. 45 yards. So that's just done most given at this point.
73705. I have an attorney, and before your attorney gets there, I also have you listed as Jane Ingersoll, Jean Arnold, Raymond James Ford. Go ahead, Council Murad.
Murad, P83665 on behalf of Mr. Jean Arnold. We waive the formal reading. Mr. Arnold stands mute. He's been advised of his rights.
Plea of not guilty. Court dates are December 11, 2024, probable cause conference followed by preliminary examination, December 18, 2024, 9 o'clock. Both matters at the Van Buren Township District Courthouse. Okay. Mr. Arnold, you have some bond conditions. You're not to go back to the Thornhill Court residence. You're not to have any contact with Aaron Ruppel. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not possessing any firearms or any other dangerous weapons. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay. All right. Detective Gooley?
Officer Gwelly, yes, Your Honor.
Okay, sir, can you tell me criminal history in reference to Mr. Arnold, pending cases, assaultive cases?
He only has one case currently through Van Buren Township for larcenies from auto. I know no history of any violence of him.
All right, thank you. Councilor Morad, go ahead, please.
Judge, Mr. Arnold wants you to know that he's 58 years old. He's a life resident in the state. He has a stable residence with his brother. He has 3 children currently in the community. He indicates that he turned himself into the tether unit. He was asked to go to the tether unit, walked into the tether unit, learned of this warrant. So he's been compliant. He's been cooperative throughout this entire process. This was actually dismissed at preliminary exam. It's a reissue. I think there was an issue with their ability to view certain footage. So they have reissued the case. I don't think that there's been any sort of violations of bond. The matter that's pending, I believe there's already a tether requirement. So my ultimate request is for you to release him on personal bond. Again, it seems that he's been compliant with all conditions. Seems that this is a reissue. He's been cooperative. He does have the priors that you see on his habitual offenders notice. He indicates that, we can see that they're all non-assaultive. He's not on probation or parole. He's earned some certified trades, including being a master mechanic. He was previously doing some mechanic and home improvement work, but currently is unemployed. He would ask the court, again, release on personal bond and to continue the conditions already imposed.
Okay. Counsel, why is he on tether?
He's got the larceny from a motor vehicle case in the jurisdiction.
Oakland County?
No, this is the Van Buren.
Okay. So he's got a misdemeanor?
No, I think that's a felony, Judge.
Okay, so that. And Van Buren, Officer Gooley, can you confirm that he surrendered to tether?
Yes, that was what the tether agent explained to me. I'm actually with Belleville, but we're at Van Buren. Used it.
Thank you. All right. In this particular matter, he's going to get a $25,000 personal bond. Sounds like he's taking this case very seriously. That concludes his arraignment. Thank you.
Thank you.
Thank you, ma'am.
You too. Councilor Murat,
Yes, Your Honor.
are you ready to do the hospital arraignment?
Yes, Your Honor. He was interviewed. I just have to grab his sheet. Hey, Loretta.
Okay.
Ready, Your Honor.
The gentleman at the hospital, please unmute. A button needs to be hit on the electronic device. Officer, can you unmute?
Yep, there you go.
Thank you. The gentleman, please say your full name, sir.
Gregory Zlotevsky.
Yes. Gregory George Leftevsky.
Yes, ma'am.
Sir, I'm Magistrate Chapter here, criminal matter, case number 240-6077-801. Sir, you have an attorney?
Brad Murat, PA 3665, on behalf of Mr. Gregory Zlotevsky, we waive the formal, we waive the reading stand mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 5th, 2024. Probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Taylor. Sir, while this case is pending, there's no assaultive or combative behavior. Do you understand that?
Yes.
Okay.
Yes.
Counsel Coyle, go ahead, Esteban.
Lisa Coyle, appearing on behalf of the people. Good morning, Mr. Murad, or good afternoon,
morning.
I should say. Your Honor, the people are requesting a 15,000 cash surety to their house arrest. This is assaultive. The reason being, as for he was a passenger in a car. He refused to exit that car. They saw him telling the driver, "Drive off, bitch, hit the effing gas." He tried to then get into the driver's seat and drive off. So I do note in his past a 2019 R&O, 2008 R&O. This is and also a history of drug offenses as well, felony drug offenses. Your Honor, there was drug paraphernalia in the car. I also note in the IR there says that there's outstanding warrants, a felony bench warrant for R&O out of the 16th Circuit Court Macomb, a bench warrant for assault out of 41B District Court, and warrant for assault out of 42-2 District Court, Your Honor, based on what I see as a pattern of behavior with those R&O convictions, and R&O that there's a bench warrant out for, also a pattern of drug convictions, a high risk flight based on this, Your Honor. So I'm asking for 15,000 cash surety to their house arrest.
Counsel Murad, go ahead.
Judge, Mr. Zlotevsky is 35 years old. He's been in Michigan his whole life. There's the only thing that I guess can be construed as assaultive is his R&O priors. Other than that, there's no assaultive cases against any civilian complainants that I'm aware of, at least. Judge, he is unable to post a monetary bond. He's not working. He has severe health issues, including organ failure and water retention issues, as well as other infections. That's why he's in the hospital now. It is charged as a 2-year. Obviously, he's being habitualized, so the maximum possible penalties go up. But I don't think that this is a specific case that Mr. Zlotevsky needs to be, held and then really remanded to the Wayne County Jail. Any monetary bond is like a remand to him. He cannot post any money. He's not working, and he is not even sure if he's able to work. But notwithstanding all that, Judge, I'm asking the court for a personal bond. I think the no assaultive behavior conditions should suffice. And if there are outstanding warrants in those jurisdictions, they would have the opportunity to pick him up on it. So I'd ask again, you release him on personal bond, maybe no drugs.
Thank you. Thank you. Court has heard the representations, both sides. Sir, while this case is pending, you're not to possess, purchase, sell, use any illegal controlled substances. Do you understand that?
Yes.
Okay. Further, once by hearing the representations from both counsels, using clear and convincing evidence standard, and reading the investigator's report, the allegations in this particular matter is very concerning. And in this particular matter is that while the gentleman was in the rear passenger seat, there was 2 other people that were in the other vehicle. It looks like that he is telling the driver to move. Not only that, but he is trying to get into the front seat or the front area so he can take control of the vehicle, telling and continuing yelling to the driver to take off. The driver did not do so, was compliant to what our officer instructions were. This court does find this gentleman to be a danger. This court is going to adopt the recommendation. I believe it's $15,000 cash surety. I'm not going to put him on a GPS tether. but $15,000 cash surety. That's unaffordable. That means he's gonna get a court date for this Monday, December 2nd, 2024, 9 o'clock in front of Judge McConigal or Judge Williams. We'll look at the bond amount and bond conditions.
George, would you consider GPS tether house arrest instead of the unaffordable cash bond?
No,
Please.
Thank
thank you though. But you asked.
You're gonna have another shot in 2 days, sir. You're gonna go before the chief judge in 2 days, and they're gonna readdress your bond, okay?
Okay.
Thank you, Your Honor.
Thank you. Oh, sorry, right here. And counsel, are you ready to start DDC?
Yes, Your Honor.
Okay, DDC, we can go down the list. What's your name, sir?
Johnny Mill, Andre Boyer.
Say it one more time.
Johnny Mill, Andre Boyer.
Oh, Boyer. All right, Mr. Boyer, this is Magistrate at Charter, your criminal matter, case number 240-6011-301. If you have an attorney, go ahead, counsel.
Brad Marad, PA 3665, on behalf of Mr. Boyer. We waive reading. Mr. Boyer stands mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Jefferson. Mr. Boyer, while this case is pending, you're not to drive without a valid driver's license. You're not to possess, use any illegal controlled substances, as well as alcoholic beverages. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay, Counsel Coyle, go ahead.
Your Honor, I can't find him on my list. Can you give me?
Sure, he's number 2 on page 1.
Oh, okay, hold on. Then he's on the, all right, I'm sorry. Lisa Coyle, appearing on behalf of the people, Your Honor. Your Honor, this case is from 2022. It's non-assaultive, although serious. The people have, I see that he's off probation back from 2023. No objection to a $15,000 personal bond in this matter.
No objection, Your Honor.
Okay, sir, you're gonna get a $15,000 personal bond. Nobody has to pay any money for you to get out of jail. That concludes your arraignment, sir.
Thank you, Your Honor.
Thank you. What's your name, sir?
Jesse Nowak.
Nowak, this is Magistrate at Charter. You're here on a criminal matter. Case number is 240-5689-501. You have an attorney. Go ahead, counsel.
Ryan Marad, PA 3665, on behalf of Mr. Jesse Novak. We waive the reading. Mr. Novak stands mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 5th, 2024. Probable cause conference followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Jefferson. Mr. Nowak, while this case is pending, there is no driving without a valid license. Writing this information on your paperwork. There is no drinking, possessing alcoholic beverages, as well as illegal controlled substances. Do you understand those bond conditions, sir?
I do.
Counsel Coyle, go ahead.
Your Honor, I'm sorry. I do not see, I'm not aware of any criminal history for Mr. Nowak. I also do not see a capious history on this case, although it's dated back from October of 20. This warrant wasn't issued until April of this year, but it nevertheless is highly dangerous as to the community that the complainant was in a wheelchair and when he was struck by Mr. Nowak, who was using narcotics. He was using fentanyl and a benzo that was found in his blood results, that he came off the roadway and struck the complainant who was on the sidewalk outside of a business. There was also a witness to this. They also found that they found 2 syringes in which after he struck the complainant, which ultimately ended in his death, he went and threw away 2 syringes and some heroin in a cap in the garbage. He does admit to all that. And that he said after he got off work, he shot up on the side of the road, and he think he fell asleep when he was driving. And he was only clean for 2 weeks prior to this. The data recorder back shows no braking, no pedal. So, Your Honor, based on the fact that he was using narcotics, admittedly, that they are in his bloodstream, although it's 4 years old, there is nothing on here to say that he is sober and clean and that this dissipates any of it as to a danger to the community. So for these reasons, Your Honor, I'm asking for $50,000 cash surety, tether, house arrest, and of course, no driving.
Okay, counsel, do you have anything new?
I do not.
This is from 2020.
I do not. I am
Okay.
not aware of anything.
Counsel Rod? Thank you,
Judge,
ma'am.
I want you to
Counsel
know,
Rod, go ahead.
I've been contacted by Mr. Nowak's employer as well as his parents. I spoke with his mother and father as well as his employer. He works at Detroit Furnace, was called about this. He actually turned himself in when he was called to cooperate. It seems that the investigator's report indicates that he was cooperating as well. I can tell you that just in talks with his family and employer as an officer of the court, that he has turned his life around. I mean, I'm looking at him now. I can just tell by his skin and by his demeanor. He doesn't give off the impression of somebody who's using or withdrawing at this time. Judge, he's 30 years old, no pending cases. He's not on any probation or parole. He's got a great job at Detroit Furnace. He's a high school graduate. He's earned a certified trade as well. I actually think he's a great candidate for a break here, Judge. I'm ultimately asking you to do a personal bond here. If you want to do a GPS tether to just track him, I wouldn't object to that whatsoever. I would just ask that if that's the route the court's going to go, that it does not interfere with his job. I did talk to his family. They are very nervous about him getting home. We all understand how serious these charges are. It's something that he's taking seriously, his family's taking seriously. And I think by walking himself into the jail today, that shows that this is somebody who's going to see this case through, regardless of which way the hammer bangs. And I can see him nodding and affirming. For all those reasons, Judge, I'm just going to ask you to do a personal bond, no tether. I'd understand if you did, but I think he's a good candidate for it.
Thank you. DDC. DDC, DDC, can you confirm that Mr. Nowak surrendered?
I'm not sure. Yes, Your Honor.
DDC, can you confirm that Mr. Nowak surrendered? I'm sorry, I didn't hear you, DDC.
They're holding up a sign that says yes, Judge. If you look at the
Okay,
TV.
thank you. Court is going to place Mr. Nowak on a GPS tether work only. He's going to get $100,000 personal bond. I'm glad that he's taken this case very seriously. But to track him, that's what the GPS tether is for, about $100,000 personal bond.
Your Honor, thank you. Would the court be willing to allow him to do a private tether company? His family's been in touch with EMS. They report directly with the Wayne County Sheriff. Would the court consider putting in its order that he would be allowed to be released to that private tether company today, as well as the
Okay.
Wayne County Sheriff tether.
I'm sorry, stand by for a moment.
Thank you, Judge.
Thank you. No. No private tethers.
Thank you, Your Honor.
Thank you. But you tried, counsel.
Thank you, Judge. Nothing further.
Thank you. Thank you. That concludes this gentleman, Mr. Nowak's arraignment.
Thank you, Judge. Lorena, can you do me a quick favor?
Deshaun Norton.
Stand by. What's your name, sir?
Deshaun Aldridge.
Mr. Aldridge, this magistrate Chuck Day here at a criminal matter, case number 24060768001. Do you have an attorney? Go ahead, counsel.
Okay, yeah, good, and good morning, good afternoon, everyone. Lorena Bijan on behalf of Mr. Aldridge, who stands mute, understands his rights, and waives the formal reading.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Mr. Aldridge, do not possess any firearms or any other dangerous weapons. Do you understand that, sir?
I'm sorry, I couldn't hear you.
Do not possess any firearms or any other dangerous weapons. No guns, no rifles. You understand that?
Yes, ma'am, for how long?
Okay. Counsel Coyle, go ahead, please.
Lisa Coyle appearing on behalf of the people. I see no criminal history that I'm aware of, non-assaultive, no objection to a 5,000 personal, Your Honor.
No objection to a personal, Your Honor. Thank you.
Thank you. Mr. Aldridge, you're getting a personal bond, $5,000. Nobody has to pay any money for you to get out of jail. Go to court, take care of your matter. You can step aside.
Thank you. Page 4 next. Gather.
What's your name again, sir? Sir, this magistrate Chuck Leah. You're here on a criminal matter. Case number 24060767001, sir. You have an attorney. Go ahead, counsel.
Good afternoon, everybody. Lorena Bijan on behalf of Mr. Birch, who stands mute, understands his rights, and waives the formal reading.
I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Taylor. So while this case is pending, you have some bond conditions. You're not to have any contact with Michael Birch Jr. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Also, you're not to possess any firearms or any other dangerous weapons. Also, you're not to go back to the West Grand Boulevard residence. Do you understand that, sir?
Yes, ma'am.
Okay. Counsel Coyle, go ahead, Esteban, please.
Your Honor, the complaint in this matter is his father, and it has to do with him questioning about his drinking at work. And allegedly, he punched his father in the throat and hit him with a metal chucking bar, and then hit him when he was down on the ground several times, in which the co-workers had to break that up. So for these reasons, Your Honor, the people are asking for a 50,000, 10% with an alcohol tether, Your Honor, with, of course, no contact.
What was the recommendation again?
50,000, 10% alcohol tether.
50,000, 10% alcohol tether. Okay.
Okay. Thank you. Your Honor, I'm gonna ask for personal.
Go ahead, ma'am.
Thank you, Your Honor. I'm gonna ask for personal bond for several reasons. There's no images, no video. I don't see any other witnesses listed. These are allegations. My client is presumed innocent, though I understand the nature of the allegations. My client can stay with another family member, so there's no issues of contact. Not aware of any KPS history. He has 2 children. He's been a lifelong resident of Michigan. He does suffer from some mental health issues. So I would ask the court for a personal bond for the reasons stated on the record.
Thank you. Court uses clear and convincing evidence standard when it's entertaining monetary bond. In this particular matter, charge is felonious assault. Read the allegations is that Mr. Nicholas Birch supposedly was drinking on the job. His father questioned him. At some point, there was a physical altercation in this matter, allegedly that there were co-workers that had to break up the fight. The complainant was hit a number of times, supposedly. And so this court is gonna put an alcohol tether using clear and convincing evidence standard. This court does believe that Mr. Birch is a danger. And I believe, counsel, you indicated, what's that, $50,000, 10%?
10%, yeah.
If they were, okay. So we're gonna go with the $50,000, 10%. Okay. We are gonna, bond, there is a bond redetermination, is that correct? I mean, it's unaffordable, counsel?
That's not affordable, Your Honor. I would ask for redetermination.
So that means he's gonna have another court date this Monday, which is December 2nd, 2024, 9 o'clock, in front of Judge McConaughey or Judge Williams. We'll look at the bond amount and bond conditions. That concludes the arraignment of Mr. Birch.
Thank you, Your Honor.
Thank you.
Sorry. State 4 minutes, 4 minutes. Jail's no good.
I'm sorry, what's your name again, sir?
Jail's no good.
Is it Foot or Foote?
The E silent.
Okay, Foot. Thank you, sir. I'm magistrate update here at criminal matter, case number 24060766901, sir. You have an attorney. Go ahead, counsel.
Lorena Bijan on behalf of Mr. Foot, who stands mute, understands his rights, and waives the formal reading.
Thank you. I'm going to enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Mr. Foot, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, sir.
Thank you. Mr. Boyle, go ahead, please.
Your Honor, the people have no objection to a $10,000 personal bond. The only thing I see in his past is a 2013 aggravated domestic violence.
No objection to a personal, Your Honor. Thank you.
Thank you. Sir, you're gonna get a $10,000 personal bond. Nobody has to pay any money for you to get out of jail. Let's go to court and take care of your matters. Good luck, sir. You
Thank
can step aside.
Hey, how y'all doing today?
What's your name, sir? Robert Allen Hester?
Yes.
I'm administrative tribunal here, criminal matter, case number 24060770001. You have an attorney, go ahead, counsel.
Lorena Bijan on behalf of Mr. Hester, who stands mute, understands his rights, and waives the formal reading.
Enter plea of not guilty, court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Taylor. Sir, you have some bond conditions. One, you're not to possess any firearms or any other dangerous weapons. You're not to have any contact with the complainant is Xander Zinger. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Understand those bond conditions, sir?
Yes, ma'am.
Counsel Coyle, go ahead, Esteban, please.
Your Honor, the people in this matter are asking for a 75,000 cash surety tether house arrest. And for the following reasons, I do note that this is October 5th, but it was not issued till the 27th of this month. And the reason being, the complainant and the defendant know each other through, the complainant was going to sell the gun to the defendant allegedly. The police tracked the identification of this defendant through Snapchat. And I note that on November 18th of this year, the defendant was the victim of a non-fatal shooting. So they took that Snapchat photo, showed it to his mother. The mother confirmed that was her son in the picture. Then on the 25th, then they went and arrested this defendant at his girlfriend's home. So then once they got conclusive identification as to the suspected perpetrator of the armed robbery, then they followed up with the mother and then went and arrested him at his house. But that he also in his statement, although he denies the robbery, admits that that Snapchat photo is him. So the evidence is great. I do not see a criminal history for Mr. Hester, but he is only 18 years old. And these are very serious charges. And based on the fact that it involves a rifle that the alleged sale and purchase of a rifle, Your Honor, I'm asking for that high cash bond based on not only being a complaint, danger to the complainant, but as to the community.
Go ahead, counsel.
Thank you, Your Honor. And I'm going to ask for a reasonable bond, Your Honor. My client is going to have his day in court. He's presumed innocent. This is an incident date of October 5th. That's Ms. Coyle mentioned. I'm not aware of any other contact with the complaining witness. My client is a lifelong resident of Michigan. He resides with his father, so he has community support and community ties. He is only 18 years old, Your Honor. He is employed. So I would ask the court to consider a reasonable bond.
Thank you. You've heard the representations on both sides. Use clear convincing evidence standard. Reviewed the allegations in the investigative report. The court does find that Mr. Hester, he is a danger. I believe the recommendation was $75,000 cash surety. Is that correct, Counsel Coyle?
It is, Your Honor. Thank you.
Not only that, and counsel, you said that he was working.
He is employed, Your Honor, yes.
Okay. So I'm gonna place it on GPS tether work only. And counsel, this is unaffordable, is that correct?
That's correct, Your Honor.
That means that he's gonna get another court date this Monday, December 2nd, 2024, 36th District Court, 9 o'clock in front of Judge McConaughey. Judge Williams will look at the bond amount and bond conditions. That concludes his arraignment.
And I'm sorry, Your Honor, the next court dates were December 5th and the 12th.
5th and the 12th.
Thank you.
Thank you. Thank you, Mr. Hester. You can step aside.
Jalen Braxton.
You gotta be out of head.
Over.
What's your name, sir?
Jalen Taiwan Braden Braxton.
ABC. Do you also have a Mr. Kohler?
Yes, no, my bad. Yeah.
If you can put him in front of the camera also. Gentlemen, you can, Mr. Braxton. You are defendant one. You can go back, Mr. Braxton. Go a little bit back. Can you hear me?
Yeah.
Okay. And the gentleman to your left, what's your name, sir?
Mr. Culver, Fred B. Culver.
Thank you, Mr. Culver. You are defending two in this case. You, case number is 240607772. Both have an attorney. Go ahead, counsel.
And Lorena Bejan on behalf of Mr. Braxton and on behalf of Mr. Culver, who both stand mute, they both understand their rights and to waive the former reading.
Thank you. Gentlemen, I'm gonna enter plea of not guilty for both of you individually. You have the same court dates, which are December 5th, 2024. Probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Jefferson. Gentlemen, while this case is pending, you're not to possess, purchase, sell, use illegal controlled substances. Understand that, Mr. Braxton?
Yes, ma'am.
Understand that, Mr. Culver?
Yes, yes.
Okay. Counsel Coyle, go ahead, Esteban, please.
Your Honor, the people have no objection to a $50,000 personal bond on both defendants.
Okay.
No objection
All
to a
right.
person, thank you.
Thank
Thank
you.
you.
With that being said,
Thank you.
gentlemen, you're each gonna get a $50,000 personal bond. Nobody has paid money for you to get out of jail. Good luck.
Thank you. Have a blessed day.
Thank you, Your Honor.
Thanks, you're welcome. What's your name, sir?
Carlos Alexander.
Mr. Alexander. Sir, this is Magistrate Chartea. Carlos Durrell Alexander.
Can you say that again? I can't hear you.
Are you Carlos Durrell Alexander?
Yes, ma'am.
Thank you, sir. I'm Magistrate Chartea, case number 24060777301. You have an attorney.
No, ma'am. Oh, yes, yes, I do.
I'm right here, Mr. Alexander. Lorena Bejan on behalf of Mr. Alexander, who stands mute, understands his rights and waives the former reading.
Thank you. I'm going to enter plea of not guilty. Court dates are December 5th, 2024. Probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Sabri. Mr. Alexander, you have some bond conditions. 1, you're not to possess any firearms or any other dangerous weapons. 2, you're not to have any contact with Lashana Red. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. It appears you and the complainant reside at the same location. From the investigator's report, you are not to go back to the Hamburg residence. Do you understand those bond conditions, sir?
Yes, ma'am. Can I ask you a question?
And before you say anything, Mr. Alexander, I just want to let you know that we're gonna have an opportunity to argue on your behalf with respect to your bond. But anything you say can and will be used against you. This is recorded, prosecution's present. So I would advise you to stand mute. And if you feel like you have anything else to say after the bond hearing, you're welcome to do so. But just know that anything you say can be used against you. So I would advise you to stand mute, but it is your right to speak.
I understand that part, but I just want to know, so I don't get out and get into no trouble. I just want to know, like, what would I have to do to get my clothes? I have a job, so I want to know what would I have to do to get my clothes from over there.
Okay.
You know,
All right, Mr. Alexander, you're gonna get a one-time opportunity with police escort to get your belongings.
okay.
All right, Counsel
Thank you.
Coyle, go ahead.
Your Honor, the people in this matter are requesting a $1,000 cash surety, tether, house arrest, no contact with the complainant. Allegedly, he strangled her with both hands. I do note in the APA note from APA Drained that dated today, that they spoke to the complainant and she is very fearful of the defendant, and she does not want him returning to the home. Based on her fear factor, this just occurred allegedly on the 26th. I do not see assaultive past in as for our criminal history for Mr. Alexander, but based on that note, based on the fact that he put his hands allegedly around her neck and then threatened to damage her car with the metal pole, those are actions that make someone become fearful of them as well, not just of the car, but as to their control over the situation. And for that reason, I'm asking for that cash surety with a tether.
What's the cash surety recommendation?
30,000.
30,000 cash surety.
Yes,
All
Your
right,
Honor.
Counsel Bashan, go ahead.
Thank you. Now, though I understand the seriousness of the allegations being made, these are allegations. There's always two sides of the story, Your Honor, and I believe a personal bond is warranted for several reasons. One, the officers don't observe any injuries whatsoever. There's nothing about any injuries whatsoever in the complaint. These are allegations. And it says in the investigator's report, the complainant was not injured, refused medical attention. So there's no videos, no witnesses, no injuries, refusing medical attention. My client can stay with a family member, so there's no issue of contact, not aware of any KPS history. He does have 3 children, lifelong resident of Michigan. He's 50 years old, Your Honor. He is employed right now, so for the reasons stated, I would ask for a personal bond.
Thank you. Court uses clear and convincing evidence standard when it's entertaining monetary bond. Started off with a personal bond basis, heard the representations of both, read the allegations in the investigator's report, and it's noted while this is November 26th, the alleged date of the offense is that there is still a note that the complainant was contacted. I don't know if she called the prosecutor called her, but there is a notation that she's still fearful of the defendant. So we're gonna go with the recommendation, $30,000 cash surety, GPS tether work only. And if that counsel, is that unaffordable?
That would be unaffordable, Your Honor. Thank you.
That means he's gonna get another court date for this Monday, December 2nd, 2024, 36th District Court, 9 o'clock. Judge McConigal or Judge Williams will look at the bond amount and bond conditions.
Thank you, Your Honor.
Thank you.
That's your drink.
Billy Spalding.
Mr. Spalding, this magistrate is there, your criminal matter. Your case number is 24060777501, sir. You have an attorney. Go ahead, counsel.
Red Marad, PA 3665. I'm here for Mr. Spalding. We waive reading. Mr. Spalding stands mute. He's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by a preliminary examination, December 12th, 2024. Both matters are in front of Judge Giles. Mr. Spalding, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
Okay. You're also not to possess any illegal controlled substances. Do you understand that?
Yes, ma'am.
Counsel, go ahead, Mr. Bond.
Your Honor, people have no objection to a $5,000 personal bond, non-assaultive, no criminal history I'm aware of.
No objection, Judge.
Thank you. Mr. Spalding, you're getting a $5,000 personal bond. Nobody has paying money for you to get out of jail. You can step aside, sir. What's your name again, sir?
Gregory Dwight French Holloway.
Thank you, Mr. Holloway. This magistrate up there, your case number is 24060777601, sir. You have an attorney. Go ahead, counsel.
Rad Marad, PA 3665. I'm here for Mr. Holloway. We waive the reading. Mr. Holloway stands mute. He's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Sabri. Mr. Holloway, some bond conditions. You're not to have, first of all, contact with complainant Portia Randolph. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the Corville residence. Do you understand that, sir?
Yes.
Okay. Counsel Coyle, go ahead. Ms. Marcia.
Your Honor, in this matter, people are asking $50,000 cash surety, tether, house arrest. Allegedly, he strangled her with both hands. Their son entered the bedroom armed with a kitchen knife by his side, and that co-defendant had then released the complainant, and then she called the police. I do note that back in 2020, there was a case in which the same victim, there was a domestic violence charge in which it was dismissed. So based on, also
No house,
officers
no-
did observe
no
bruising
house.
around the complainant's neck.
Yeah, no address. Okay.
Based on
thank you.
that, Your Honor, I'm asking for that bond with no contact.
Again,
That's
give me the
not true, though.
recommendation, Counsel. Mr. Holloway, please don't say anything because everything is being recorded and can be used against you. So Counsel Coyle, give me the recommendation again, please.
Your Honor, I'm asking for 50,000 cash surety, tether house arrest, no contact.
5-0, is that correct?
Yes, Your Honor.
Okay. All right. Counsel Murad, go ahead, Esteban, please.
Judge, a couple of good things I want to tell you about my client. First things first, he understands to have no contact with the complaining witness. He will be residing with his mother while the case is pending, not with the complaining witness, or the location of the alleged incident. Judge, he indicates he doesn't have any cases pending against him now. He's not on probation, he's not on parole. Unfortunately, he's not employed, so he can't post any money. A highlight he wants, to leave the court with is he understands that the complaining witness may have cameras in the home. He indicates that he wants to alert the court, that he wants to get a hold of that footage because he indicates that it's going to be exculpatory for him. He indicates that he's disputing the allegations, but nonetheless, he understands to have no contact. He understands that he's charged with a felony case and it is serious. I don't see any sort of habitual offense notice. I don't see any felony convictions whatsoever. I'm not aware of any capious history. I think the court likes to keep these parties away in these cases. It doesn't seem that anyone went to the hospital here. So I'd ultimately ask you for personal bond. If you're going to do a GPS tether, we'd understand. Ultimately, we'd hope the court would just release him on personal bond. But nonetheless, if you release him on personal bond and GPS tether with any restrictions you want, even house arrest, we wouldn't object to it. So that's the bond that we're asking for, Judge.
Thank you. Court uses clear and convincing evidence standard when it's entertaining monetary bond. In this particular matter, we started off with personal bond basis, read the allegations in the investigative report, heard the representations from both counsels. The court does find in that allegedly that he did strangle the complainant, Ms. Randolph, but it was the complainant's son who got in between the complainant and the defendant. And then in this particular matter, okay, so the court is gonna adopt the recommendation, $50,000 cash surety. There's also gonna be placed on a GPS tether. Counsel, does he work?
No, Your Honor.
Okay, then there'll be a house arrest. And this is unaffordable, is that correct, counsel?
Yes, Judge.
That means he's gonna get a court date for this Monday, December 2nd, 2024, 36th District Court, 9 o'clock, in front of Judge McConicle and Judge Williams, who'll look at the bond amount and bond conditions.
Thank you, Your Honor.
Thank you.
My name is Desmond Gentry.
Mr. Gentry, Desmond Lorenz Gentry, sir?
Yes,
Sir, I'm Magistrate Chapter here, criminal matter, case number 240-60-77701. You have an attorney, go ahead, counsel.
Red Murad, P83665. On behalf of Mr. Gentry, we waive the reading. Mr. Gentry stands mute. He's been advised of his rights.
I'm gonna enter the plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Mr. Gentry, while this case is pending, you're not to possess any firearms or any other dangerous weapons. Do you understand that, sir?
yes, I understand.
Okay. Counsel Coyle, go ahead.
Your Honor, non-assaultive, no objection to a 5,000 personal in this matter.
No objection.
Thank you, Mr. Gentry. You're gonna get a $5,000 personal bond. Nobody has paying money for you to get out of jail. Good luck.
Thank you, Your Honor.
Thank you. Appreciate it.
Forgot to write it down. That's why I took it back. Otherwise, you'd be yelling at me. Yeah, you'd be looking at me. I could just hear the yelling in your voice, in your mind. All right, the gentleman at DDC, what's your name, sir?
Marquise Campbell.
Mr. Campbell, this is Magistrate Charter. You're here on a criminal matter, case number 240-6077-901, sir. You have an attorney. Go ahead, counsel.
Ryan Marad, PA 3665, on behalf of Mr. Campbell, we waive the reading. Mr. Campbell stands mute. He's been advised of his rights.
Enter plea of not guilty. Court dates are December 5th, 2024. Probable cause conference followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Mr. Campbell, while this case is pending, you're not to possess any firearms or any other dangerous weapons. Do you understand that, sir?
Yes, ma'am.
Okay. Counsel Coyle, go ahead, Esteban, please.
Your Honor, the people are requesting a $15,000 personal, but I'm asking for a tether in this matter because he currently is on probation under HIDA status for a gun. He was placed on probation, it looks like in February. He got 18 months probation, and here he is with a stolen gun again, and he's only 19 years old. I have no objection to a work-only tether, but I'm asking for a tether, Your Honor.
Thank you. Counsel Marad, go ahead, please.
Your Honor, I'm asking for a personal bond, no GPS tether here. He's 19 years old. He is on that height of probation that Ms. Coyle mentioned. You know, the reason I guess I'd be objecting to the tether is it would be one thing if he was failing to appear, had many outstanding warrants, and needed monitorization to ensure he's been compliant with bond. He's post-sentence, he's not on bond. There's been no bond violations that I'm aware of, no capious history. I think that you know, a tether shouldn't be imposed to punish him for getting a new case. We think that he's previously demonstrated that he's shown up to court, followed court orders. At this time, Judge, he's a high school graduate. He has a stable residence with his girlfriend and her mother. He's been in the city of Detroit his whole life, nothing violent about him. And from my knowledge, he's showing up to all his court dates. Didn't hear the court arraign him on any traffic warrants. For all those reasons, I'd ask the court for personal no tether.
Thank you. Counsel, does he work?
No, Judge, he's not employed at this time. He recently graduated high school.
Thank you. What's concerning is that the case that he has already, that he's under HIDA, okay? So he already knows that he's not to possess any firearms. And yet, supposedly, the allegation is that he has this firearm is stolen. So it's not just, the court feels it makes it worse because it's not only just a firearm, but it is a stolen firearm. He's running away from the police. Allegedly, he throws it. The police recover the firearm. It's loaded. So
My only point to that.
Go ahead.
Sorry, Judge. My only point to that is that if those are indeed the facts of the case and he ends up being found guilty or pleading guilty to this, that should, I think, most appropriately be taken up. That issue that you have, Judge, should most appropriately be taken up by the sentencing judge. But we're a long way from there. This is a CCW case where his first probable cause date is going to be on Zoom. You know, a judge can give Mr. Campbell HIDA without prosecutorial consent. This isn't a case where he's going to be expected to do time. This is a case that he is really probationary. That's what his guidelines would be anyway, despite the fact that he's had HIDA once. And maybe he doesn't get HIDA again, but this isn't a case where he's not showing up to court. This isn't a case that he's, you know, has a bunch of warrants outstanding or is picking up new cases while on bond. I know he's picking up a new case on probation, but because that case has been resolved, because this case doesn't contain any assaultive components and there's been no other capious history, I just don't believe it would be most appropriate for a tether. I think that would be used to punish him when he's presumed innocent, Judge.
The court doesn't see it as punishing your client, Mr. Campbell. The court does see is that he has a firearm, a stolen firearm. He already knows that he shouldn't be possessing it. Okay. And then he runs from the police, allegedly tosses the firearm. The firearm could have gone off. It is loaded, okay, in this particular matter. So now we're going to give him a personal bond, but we're also going to place him on a GPS tether house arrest.
Okay.
Thank you. That concludes Mr. Campbell's arraignment. $15,000 personal bond. I thought I said that. Okay. I'm sorry, what's your name, sir? Are you Corey DeAndre Matt?
Yes, ma'am.
Okay. Sir, you are defendant one in this case. DDC, do you have the co-defendant, Mr. Joseph? DDC, do you have Mr. Joseph? And if you do, can you put him in also in front of the camera?
He left the state prison. Not here.
DDC, did you say he's not present?
Gone. He's not here.
Ms. Marcia?
He's not present, Judge.
Okay, all right, then let's do Mr. Mapp. Mr. Mapp, you are defendant one in this case, case number 24060780001. Sir, you have an attorney?
Ryan Murad, P83665. On behalf of Corey Mapp, we waive the reading. Mr. Mapp stands mute. He's been advised of his rights.
Enter plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Jefferson. Mr. Mapp, while this case is pending, you're not possess any ammunition of any kind or any firearms of any kind. You understand that, sir?
Yes, ma'am.
Okay. Counsel Coyle, go ahead, Esteban, please.
Your Honor, in this matter, the people are requesting a 10,000 cash surety with the tether. I do note that he is the passenger in which he's, once the vehicle came to rest, fled from the officers and he resisted arrest. The gun that was found under the passenger seat was stolen. I don't know if he's on probation. I see a 2024 disturbing the peace out of the 19th District Court. But I do see that he was discharged from parole in June of 23. So he's not on parole as far as I know, but he does have assaultive background. He has a 2015 great bodily harm, gang membership, and felony firearm. So he's facing a second felony firearm charge here. For those reasons, Your Honor, based on the fact the people are and the dangerousness to the community, I'm asking for a 10,000 cash surety tether house arrest.
Counsel Morad, go ahead, Esteban, please.
Judge, Mr. Mapp is 31 years old. He is a life resident here in the city of Detroit. Yes, it's no secret. He does have I think it's a 2015 convictions, the assault conviction. Judge, he's a high school graduate. He has a family size of 3 he supports. It looks like he's being charged with resisting and obstructing and the possessions of contraband, really firearms and ammunition. I don't see a need to keep him in the Wayne County Jail while this case is pending. I don't see that with his priors that he's ever failed to appear, that we need to track him or that we need to keep him in jail to make sure he shows up to court. It doesn't seem that there's any civilian complaining witnesses who are subject to this case at all. For all those reasons, I'd ask the court to release him on personal bond, ultimately also noting that he was a passenger in this vehicle, allegedly. He's working at a factory. His days and hours do vary, but we would ask the court ultimately for personal bond, no possession of firearms, and any other conditions the court sees fit. He's also been
thank
in
you.
for
I just want.
the last 3 days. Sorry.
Hold on.
I'm sorry, Mr. Murad. I apologize. No, I just want to tell Mr. Murad, I am looking at the warrant. He is charged with RNO. He's count 7. I'm
Yes,
sorry. I
yes.
thought you said he was not. I'm sorry. I
Oh,
just
no,
want to make
he
sure
is.
that
He-
you knew. Okay,
Yeah, he is.
no
Okay.
problem. Thank
Thank
you.
you.
I'm sorry.
All right. Counsel Coyle, what was the recommendation?
10,000 cash surety tether tether house arrest.
Okay, well, first of all, some bond conditions. Mr. Matt, no assaultive behavior, no assaultive or combative behavior, GPS tether work only. I see that he was struggling with the police in this particular matter. He was passenger in this motor vehicle. Allegedly, he did have a firearm. That firearm was loaded. And Council Coyle, I just want to make sure, you've indicated that he is no longer on parole. He was discharged.
I'm looking at his Otis. Let me go back. Yes, I see it shows he was discharged June 30th, 2023.
Last year. And then is that the GPS, excuse me, not GPS, GBH
Yes,
conviction?
it looks like he had a gang membership association that he got 4 to 20, GBH 4 to 10, and a felony firearm. Those I think were that's what he was discharged from parole on.
Okay, thank you. This court uses clear and convincing evidence standard, though he was fighting or struggling with the police, whatever the interpretation is, the allegations in the investigator's report. There's nothing to indicate that there's a KPS history or he did not show up at court. Is that correct, Counsel Coyle?
I am not aware of any. Yes, Your Honor.
Okay, with that being said, he's gonna get a $50,000 personal bond. That concludes the arraignment of Mr. Mapp.
Thank you, Your Honor.
Thank you. EDC, see you on the female side.
Was Mr. Joseph released? I didn't catch that. I'm sorry.
Yeah, I know, I'm trying to get that also. We got that from Mr. Murad.
I just got that he's not in there. I don't know if he was in there or not, but we didn't interview him. We were told he wasn't there.
Gotcha. Okay,
Okay.
thank you.
Thank you. EDC, I'll see you on the female side.
Say your full name, Judge.
Jasmine Nicholson.
Ms. Nicholson, this magistrate in Champaign, you're here on a criminal matter. Case number is, let's see, where is it? 240567250, ma'am. You have an attorney. Go ahead, counsel.
Ryan Murad, PA 3665. On behalf of Ms. Jasmine Nicholson, we waive reading. Ms. Nicholson stands mute. She's been advised of her rights.
Thank you. I'm gonna enter plea of not guilty. Court date December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Ms. Nicholson, you're not to possess any firearms or any other dangerous weapons. You understand that, ma'am?
Yes.
I would also indicate on June 14, 2024, a warrant was issued for Ms. Nicholson. She failed to appear. Bond was set at $1,000, 10%.
Judge, we'd ask that bond continue.
Okay. Is that unaffordable?
No, it's affordable.
You know that for sure, counsel.
Ms. Nicholson, you can pay that $100, right?
You said I can?
Yes,
Yes.
Okay,
yes, Your Honor.
all right, so her bond is gonna be $1,000, 10%. Okay, she's got a affordable hearing date for tomorrow, which will be in front of me, which will be November 29th, 2024, 9 o'clock for the affordable hearing.
Thank you, Your Honor.
Thank you.
This way, Jack.
Have a seat, chair, so you pull down.
Anika Kennedy.
Stand by, Ms. Kennedy. There we go. Ms. Kennedy, this magistrate at Chapter, you're here on a criminal matter, case number 24060777401. Ms. Kennedy, you have an attorney. Go ahead, counsel.
Rad Murad, PA 3665. On behalf of Ms. Kennedy, we waive the reading. Ms. Kennedy stands mute. She's been advised of her rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024. It is a probable cause conference followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Taylor. Ms. Kennedy, while this case is pending, you're not to have any contact with the complainant. Anne Marie Toussaint, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. You understand those bond conditions, ma'am?
Yeah.
Okay. Counsel Coyle, go ahead, please.
Your Honor, I do not see a criminal history for Ms. Kennedy, but then that it appears that the defendant believed that the complainant was cheating with her boyfriend, Mr. McCord. And so she then pulled out again and threatened to F both of them up. And the complainant says she sees the defendant pointing the gun at Mr. McCord. She turns around and then she's pointing the gun at her. The defendant fled the scene. I do note that this happened on November 3rd. On the 21st, that the complainant makes her written statement to the police. She also is participating in a photo show. She identifies the defendant. And then on the 26th, they do a search warrant execution at the defendant's home, and that they find a pawn ticket and that she pawned one of her weapons. She did at the time possess a CPL. She had 2 guns registered to her, Your Honor. It's very interesting that she went and pawned her weapon after this occurred. So based on the assaultive nature of the crime being a danger not only to Mr. McCord, but although if he doesn't want to prosecute, Ms. Toussaint does, I'm asking for that $25,000 cash surety, tether, house arrest, no contact.
Hold on for a moment. Is it an emergency? Yes. Fine. Okay, Council Murad, go ahead, Esteban, please. Sorry for the interruption.
It's okay, Judge. I'm asking the court to consider personal bond in this particular case. Ms. Kennedy's 47 years old. She's had no prior criminal convictions, no pending cases, no probation, no parole. I don't think she's ever been on probation or had any cases. She's gainfully employed at the Greyhound, Your Honor. She is working. She suffers from heart disease, taking some medication that she has not received. Your Honor, she does indicate that she, is maintaining her innocence, is advising that there was never a weapon drawn, and complaining witness was, at her car, and my client just disputes ever drawing a weapon. Obviously, this is another case where there's not independent surveillance. There is Ms. Kennedy who's making a statement, who wants to move forward in prosecution, or I'm sorry, Ms. Toussaint against Ms. Kennedy. And this is going to be a case that there's going to be an exam conducted, and however it resolves. But it looks like it's from November 3rd. It took at least 3 weeks to get signed. I have nothing before me that tells me that there's been any issues between Ms. Kennedy and the complainant in this last month since this alleged date of offense. She's a mother of 5. At least one of her children is a minor. I know that she cares for them. I would ask the court to do a personal bond here with the no contact order. I don't think there's been any contact. I think that these are parties that didn't necessarily have a relationship, at least with, the listed complainant and my client. So I don't think that there would ever be a reason for them to come into contact with one another. And I don't think that's happened within the last month since she's been out in public. For all those reasons, I'm asking for personal bond, no contact, maybe even no firearms. I know she's a CPL holder, tells me that she's passed CPL background checks as well. I'm asking for personal here, no contact, Judge.
Thank you. Court heard the representations, both sides, this particular matter uses clear and convincing evidence standard when it's entertaining a monetary bond. The court is considering a monetary bond, but we are going to place Ms. Kennedy on a GPS tether, work only. Okay. While this allegedly happened November 3rd, reading of the allegations, it does show that the complainant did provide a written statement back in November 21st. And then not only that, it's the same day, she did a positive identification in this matter. It also shows that exactly somewhere a warrant was found, a search warrant was done. They found that allegedly Ms. Kennedy, she pawned that may be the gun in question. But what we're gonna do is we're gonna give Ms. Kennedy a chance. She's gonna get a $50,000 personal bond with a GPS tether.
Thank you, Your Honor.
Thank you.
Take a chair. Say your full name. Okay, Carlisle.
Ms. Carlisle, this magistrate at Chartea. Ma'am, you're here on a criminal matter. Case number is 2406077-101, ma'am. You have an attorney.
Ride Marad, PA 3665. On behalf of Ms. Carlisle, we waive the reading. Ms. Carlisle stands mute. She's been advised of her rights.
I'm gonna enter plea of not guilty. Hold on. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination. December 12th, 2024, both matters are in front of Judge Giles. Okay, Ms. Carlisle. bond
Sorry, Judge, can I get that
conditions,
date one more time?
Sure. December 5th and December 12th, Judge Giles. Ms. Carlisle, you're not having contact with the Mary Annette Wilson. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. There's no assault or combative behavior on your part, and you're not to possess any firearms or any other dangerous weapons. Do you understand that, ma'am?
Yes.
Counsel Coyle, go ahead, ask the bond, please.
Your Honor, the people in this matter, I don't see a criminal history for Ms. Carlisle, but what is concerning to me is not only this happened at her work, and she not only fought with Ms. Wilson, but allegedly resisted arrest. But what is in the IR, which is dated November 20, it says on Wednesday, November 27th at 8:47 this morning, when the officer presented the warrant, they said they got a call from DDC that she was allegedly telling the complainant to drop charges, I have to go to work. And then she was also heard saying that she was going to beat their ass when she gets out. Highly concerning, Your Honor. So I have no idea, but based not only on the fact that she was fighting allegedly with Ms. Wilson, but also with the officers. For this, Your Honor, I think she poses a danger to the community as well as to Ms. Wilson. So for that, I'm asking for a 10% with a tether, no contact.
Thank you. Counsel Marad, go ahead, please.
Judge, Ms. Carlisle is 29 years old. She's a licensed barber, but her income still has her within the poverty guidelines. She's completed barber school. She currently is homeless, Judge. She has a mailing address, but she doesn't have a stable residence. But she understands that she has to show up to court. The complainant witness is an old coworker. She understands not to have any contact with the complainant. It doesn't appear that there's anything domestic between them. She does take some medicine for high blood pressure. She's received that in the jail. Ultimately, Judge, I think on both of these cases, I've never seen these convictions result in anything but probation. I do think a monetary bond will only increase the time that she's going to spend in the jail, depriving her of her liberty. Because there's no previous history with her and with this complainant or really anybody, I don't see a reason to keep her in the jail. I think 2 days in probably one of the worst places in the world is enough to keep her away from the other party. She understands that obviously since this contact, there hasn't been a no contact order until now, so she wasn't in violation, but she understands now that this court's ordered no contact. So if she contacts Mary Wilson and tells her to drop the case, she's just gonna get picked back up and locked up. And I think that's been made very clear on this record. And I think for all those reasons, Judge, it would be appropriate to release Ms. Carlisle on a personal bond. And I know Ms. Coyle will have an APA note of this issue of contact. And if there is any contact by pretrial, her bond will be revoked and she'll go back to jail. I'd ask for a chance on her behalf because there's no criminal or KPS history. And she understands what's at risk here, Judge.
Court heard the representations, both sides, uses clear and convincing evidence standard when it's entertaining a monetary bond. Court read the allegations. And what's concerning is that even though she gets arrested, allegedly she makes a statement or is heard making a statement by phone to drop the charges, that she's got to go to work. Also, part of the statement is she's going to beat their ass when she gets out. That's concerning to the court that Ms. Carlisle is a danger. So court is going to adopt the recommendation, $10,000, 10%. She's going to be placed on a GPS tether, and counsel, she's under house arrest.
Could she
And
work only,
because-
Judge?
is that- Pardon me?
Could she do a work only?
She can't go back to the location where the complaint is.
Of course not.
I don't work at that location. I work at a different barber shop.
I'll do all the talking for you, okay, Ms. Carlisle?
Okay, I'm
So
sorry.
I'll let her go. Work only. This is unaffordable, counsel?
Correct, Judge.
Okay, that means, Ms. Carlisle, you're gonna get another court date this Monday, December 2nd, 2024, 9:00 in front of Judge McConaughey, Judge Williams, that will look at your bond amount and bond conditions. Do you understand that, ma'am?
Can you repeat that one more time, please?
Sure, and you get another court date this Monday, 9:00. Judge Williams or Judge McConaughey will look at your bond amount and bond conditions. Do you understand
Okay.
that?
Yes.
All right, thank you, ma'am. That concludes your agreement.
Thank you, Alice.
Thank you. EDC, I believe that's it. Happy Thanksgiving.
I believe that's it, Your Honor. You guys have a great holiday. See you guys tomorrow.
Thank
Have a nice
you.
Thanksgiving, everybody.
Happy Thanksgiving.
Yes.
Madam
Yes, sir.
will it also be a weekend holiday schedule for tomorrow as well?
Will I be doing the arraignments tomorrow? Yes.
Weekend holiday arrangements, just one tomorrow?
Just tomorrow. And then, of course, Judge, Magistrate Burton will be doing Saturday and Sunday.
Thank you, Your Honor. Have a great holiday.
You too.